Hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you.
Good morning,
Good
Your
morning. Good morning, and welcome to the Massachusetts Appeals Court oral argument session for December 1, 2020. I'm Justice Greg Massing, and with me is Justice Peter Sachs and Justice Marguerite Grant. The first case is Commonwealth versus Dew, 2019 P 1696. Mr. Dew, you have 15 minutes, and I suppose we'll give you some, we'll let you know as it goes along when your time's getting close. So,
all right.
Go ahead.
Good morning, Your Honors. I come here today for appeal of my motion for 278A DNA testing. DNA testing would exonerate me for forensic crimes because I'm not the perpetrator who sold these drugs. Never was. The Boston police officer, Robert Chabanero, filled out for a search warrant application. In that search warrant application, he swore under the pains and penalties of perjury. And at that time that he swore under pains and penalties of perjury, he goes back in an affidavit. If you look at my reply brief, do y'all have my reply brief, page 87?
We have it.
Your Honors?
Yes, we do.
All right, so in his affidavit, he stated that he made 3 controlled buys. When he applied for this search warrant on January the 13th, 2015, he said within 72 hours he made a drug control purchase. The Boston police stated that the drugs was field tested, then forwarded to the state police crime lab for analysis on January the 10th. Then they went to December 31st, 2014, and they said they made another drug buy, field tested, then forwarded to the lab. Then they said on December 1st, 2014, they made another drug buy, field tested, then forwarded to the lab. Each time, Officer Robert Chabanero is not working. I sent y'all his payroll schedule for January the 10th, days off for meritorious claim. December 31st, off for paid salary leave, not working. December 1st, not working. So at the same time, Your Honor, I'm asking that y'all give me the opportunity to grant DNA testing to show to y'all that the officer was unforthcoming with the truth when he signed before Judge Peter M. Lariat.
So if you what DNA testing would you like to have done?
I would like to take the drug purchases to show y'all that no crime never was committed, and I'm not the perpetrator of the crime, that the officers, excuse my language by saying this, was unforthcoming with the truth. If we order the Commonwealth to produce the drug bags for DNA testing, right, which they can't because the Boston police sent me documents saying that we don't have no drug purchases for 49 Maxwell, for Robert Chabanero, James Miller, and Daniel Nichols, who applied for this search warrant application. If we order the Commonwealth to produce the chain of custody and the evidence log, it will show that the Commonwealth and its agents is unforthcoming with the truth.
So you want to test the baggies or supposed baggies from the 3 supposed controlled buys. Is that correct?
Yes, Your Honor, and that'll show that I'm not the perpetrator, that the
Right.
police was unforthcoming with the truth.
So here's my question. Under 278A, Section 3, one of the things that you have to allege in your motion is that the DNA analysis has the potential to result in evidence that's material to your identification as the perpetrator of the crime in the underlying case. As I understand it, you were convicted or you pled guilty not to anything having to do with the 3 controlled buys, but rather to furnishing controlled substances to 9 individuals and other human trafficking offenses. So even if it could be proven that you had nothing to do with these controlled buys, or even that they never occurred, how would that demonstrate that you were not the perpetrator of the crimes to which you pled guilty? Mr. Dew, are you still there? Mr. Dew?
Ms. Ryle, can you hear us?
Yes, I can hear you.
Is-
I still have him merged on the call.
But you,
Mr. Dew, do you need more time to think about that question? We need to know that you're still there on the call. Mr. Dew, are you able to hear us?
Patricia, what facility is he at?
MCI Norfolk. If we would like to pause, I would try to reach back to the extension that I would
Yeah.
connect with him with.
Give it a try.
Okay.
I think we were about 5 minutes.
Hello,
into
Your
it.
Honor.
There we go.
Hello?
Hello.
Okay.
So we lost you there, Mr. Dew. Sorry about that. We think you got about 10 minutes left. I'm not going to count any of that time against you that we lost the connection. So Justice Sachs had a question. I think he's going to repeat it one more time.
Yes, this is Justice Sachs, Mr. Dew. My question is, even if it could be proven that those controlled buys never occurred or that you had nothing to do with them, under Chapter 278A, Section 3, you can only get DNA testing if it would have the potential to result in evidence that you weren't the perpetrator of the crime in the underlying case. And as I understand it, you didn't plead guilty or were you otherwise convicted of anything having to do with the controlled buys. Rather, you were convicted of offenses related to distribution to 9 separate individuals, not a confidential informant. So how would the testing of the alleged drugs in the alleged controlled buys show that you didn't sell drugs or engage in the other offenses to which you pleaded guilty?
So, Your Honor, if we was to test these bags, right, it showed that the officers was unforthcoming with the truth about probable cause 3 times. That's what established them to get this search warrant. If they would have never went to Judge P. Lariat and said, yeah, I did this, I did that, I did this, and the judge is under the assumption that these officers told him the truth. But if we was to go and get the order to Commonwealth to produce the chain of custody, which Judge Haynes said I had a 6610 remedy, their own agency says we do not have no drug buys for 49 Maxwell from December the 6th, 2014 to January 13th, 2015 when Mr. Dew moved in this location. So what is that saying? That's saying that Mr. Dew's coming to y'all today and telling you I'm not the perpetrator of the crime.
Well,
Let's have these bags tested. If the officers never lied to the judge, they would never enter 49 Maxwell Street, and I'm not the perpetrator of the crime. So if the officers, go ahead.
Sorry, Mr. Du. I understand your point that if these controlled buys never occurred, or that if you had nothing to do with them, that might have some bearing on the validity of the search warrant, might even invalidate the search warrant. But 278A does not provide a remedy that I can see for challenging search warrants. It's what it is a remedy for challenging whether you were the perpetrator of the crime in the underlying case, which is the charges that you pleaded guilty to. So how would invalidating the search warrant change the fact that you pleaded guilty to 9 counts of distribution of controlled substances to 9 different people and the other crimes of human trafficking and so forth?
Because my lawyer told me to plead guilty. I sent y'all a letter with Richard Doyle said it's not on him to check the search warrant. It's on Perullo. It's on Perullo. So if he was ineffective to me, right? He was ineffective assistant counsel. I would have chose to go differently. I'm not the perpetrator of none of these crimes. And if the officers are unforthcoming with the truth about the drugs, what else is the officers come forth truth about? Because they did this jointly. They did a joint operation. So if one's not telling the truth, how does it say that the others is telling the truth? We'd never know that because the officers was unforthcoming with the drug buys. So when they was unforthcoming with the drug buys, what else are they hiding in this case? One would want to think that.
You had a previous appeal in this of a different motion for new trial where you argued that Charbonnier was lying and that you're entitled to a Franks hearing. Is that correct?
Yes, if I had a Franks hearing, if Richard Doyle would have stepped to the plate as my lawyer like he was supposed to do and do this, but he says, no, I'm ordered to be ready for trial. So if I never had no hearings, we'd have never knew that this officer was lying. This is newly discovered evidence. If I'm not the perpetrator of this crime, Your Honor, one would have to think, if Detective Robert Charbonnier was unforthcoming with the truth in this search warrant, what about the previous ones and the other ones that he'd been doing? If he lied here, if y'all give me the opportunity to reverse this down for a hearing and put him on the stand and ask him the questions, and if he lied there, this will show what else in this case is a lie. What else are they covering up?
Okay, I think we understand that argument. Are there other arguments you'd like to make?
No, this is my main argument right here. Those drug control purchases, a show. If y'all order the Commonwealth and the officers to produce them, they'll show that the Commonwealth don't got the chain of custody. He don't got none of this because he know that these officers was unforthcoming with the truth.
Mr. Du, I wanted to ask you, this is Justice Sachs, about your other claim that the judge should have recused herself. Since you didn't make that argument to the judge herself before the, in the motion proceeding, part of the test for whether a judge needs to recuse him or herself is that the judge is supposed to examine his or her own conscience and decide whether he or she can be neutral and unbiased. Where you didn't raise the issue, we don't have any findings or memorandum from the judge about whether she felt that she could be neutral. So how are we supposed to review her decision on recusal when she never actually made one?
Well, here's my main argument on that perspective. I'm not being disrespectful in no way, Your Honor. If I knew that she was who she was on the Directors for Judge on the issue of the International Association, I would have asked her or Richard Doyle could she please recuse herself? Because at the time, I'm not no law expert. And if I would have knew the things that I know now, that these officers was unforthcoming with the truth and that Judge Giles was what she is, whatever her preference is, I would have asked her to recuse herself because on the nature of the crime. The nature of the crime was a serious crime. And I thought in her mind, when the Commonwealth was offering me 5 years, they said, you could take 5 years and lay down and you get to go home in 5 years. If I would have knew that the lawyer wasn't going to do what he was supposed to do and ask Judge Giles to recuse herself because he knew this, she should have recused herself and gave me an opportunity to fight in the ring with the up little bit of the integrity to pick a jury, but she wasn't. She was going to give me a harsher sentence. Your Honors?
Yes. Yeah, so you have about 2 minutes and 53 seconds. If there's more you want to say to us, feel free.
I just want to say, if y'all could just take it and just hear my side as a pro se litigator and look into this. The officer was unforthcoming with the truth. Ask Houston Armstrong, could he produce the drug purchases and a chain of custody that went to the state lab? And if he can't, that's telling you, as an officer of the law and an officer of the court, which he is, that he's still hiding something. And I'm innocent. I'm innocent.
I have a question. This is Judge Grant.
Yes, ma'am.
If we were to look at the search warrant affidavit, and let's say that we were to disregard anything about the controlled buys in the search warrant affidavit, would there still be enough probable cause from the search to look for the various pieces of the items that have been seen on back page and the cell phones and the necklace and the other items that were connected to the human trafficking crimes?
None of those cell phones, none of that was mine. I was only responsible for one cell phone, and that was my phone that I bought when I go to work every day. I just rented the room. I didn't have nothing to do with nothing. So if we was to get DNA testing of the phones, that'll still show I'm not the perpetrator. My DNA's not on none of that. So if the perpetrator is who he say he is, let's test the bags, because that could be the perpetrator that control buys. That could be the perpetrator, but could the Commonwealth produce them? That's one thing. If you take those items out of the search warrant, just because they colluded, we know if they collude together, if one's telling the truth and the other's telling a lie, how can we believe either one of them? If me and you go before Judge Sachs and say we swearing under oath under pains and penalties of perjury, and I'm untruthful, that reflects to you, Judge Grant. What you do reflects to me. If we're doing this jointly, we're doing this together. We going to the judge and swearing under oath together. So if you knew I lied, and so what if I lied, but I got you in the door? That got you in the door to find all these fruits of the poisonous tree. So if that happened, now come to find out, Mr. Dude's finding out that you lied, that reflects to your work. Oh, but I told the truth and you didn't tell me you lied. If we put these officers on the stand and get the truth out of them, that'll show that they lied. And like Judge Crump said, if they lied, they deserve to go to jail. When he says, Mr. Dude, you don't have no evidence to showing that the officers was unforthcoming with the truth. Now I got the evidence to show that the officers was unforthcoming with the truth. They should pay.
Okay, well, so the 15 minutes are up. Thank you for your argument. You've very well argued. At this point, we'll hear if ADA Armstrong wants to say anything in response. We've got a few questions for him. So hang on the line and just listen for the rest of it, okay?
Yes, sir.
Thank you. ADA Armstrong, can we hear you now?
Yes, Your Honor.
Okay, floor is yours.
Good morning, Your Honors. May it please the court, Houston Armstrong on behalf of the Commonwealth. This court should affirm the denial of the defendant's 278A motion for post-conviction forensic testing because his motion failed to satisfy the statutory requirements, specifically that the requested evidence would not have been admissible at his trial, which is under 278A section 3B2.
Mr. Armstrong?
Yes, Your Honor.
This is Justice Sachs. Can I ask you about that point? I don't see where in section 3B2 of 278A it says that the evidence must be admissible at the trial of the underlying offenses. What I see it saying is that it must be, I think it's admissible in the courts of the Commonwealth. But I don't see a requirement that be admissible at trial. Wouldn't this kind of evidence that Mr. Dew is looking for have been admissible if, for example, there was a suppression hearing?
It would be admissible at a suppression hearing, certainly, but that also would depend on if you're challenging the search warrant. If it's a search warrant, then you're looking at the four corners of the search warrant. And so there wouldn't be an evidentiary hearing. It would just be based on the search warrant itself.
Well, so there could be a Frank's hearing, for example.
Sure, certainly, Your Honor.
So it would be admissible in those circumstances. Is there a requirement that I'm overlooking in 3B2 that says that in order to get testing, you have to show that the evidence would have been admissible at trial?
I understand Your Honor's point, and I take that. I would interpret it as being admissible at his trial, because the whole purpose of 278A is to ensure there is no exculpatory evidence that could be introduced at trial, or any specific evidence that's going against the defendant. So if you're not looking specifically at the defendant's trial, I'm not quite sure what relevance that would have on the DNA testing.
So you're saying that because it's not relevant to the issues at trial, it wouldn't be admissible?
That's correct, Your Honor.
But isn't relevance incorporated in 3B4 about whether it would tend to show that the person is not the perpetrator of the underlying crimes?
I believe relevance would apply to both of those standards. And in this case, Your Honor, both of those standards were not met by the defendant's showing, because the requested testing was from, as Your Honor and Justice Massing pointed out earlier, was from uncharged conduct. So even if testing was done to these bags and it came back with evidence that was not exculpatory or even inculpatory to Mr. Dew, that would have no bearing on the underlying convictions. And for that reason alone, a hearing was not justified.
Mr. Armstrong, this is Justice Sachs again. What do we do with the recusal argument, which you say is waived? I understand that we're in not a great position to review a decision that was never actually made about recusal, but don't we still have to engage in some kind of substantial risk of miscarriage of justice review?
I don't believe so, Your Honor. Where a defendant has filed over 40 motions of post-conviction relief, all of which have been directed to the plea judge, who is still sitting and has reviewed all of them. For the first time on appeal, there's no reason that a claim like this should be reviewed without any record or without any evidence to support that. At best, it could be remanded for the judge to make findings and rulings as to her ability to remain fair and impartial. But I don't even think that's appropriate here, where there hasn't been any showing by the defendant of any record evidence or any facts that would support recusal. But I would say that this court should view it as waived for those reasons as well. And you're welcome, Your Honor. If there's no further questions.
I have one. This is Justice Massing.
Sure, Your Honor.
Do the 3 bags of heroin that were purchased by the confidential informant named Jet, do they still exist somewhere?
I would not have the ability to know that, Your Honor.
You don't know?
No, I do not know.
Okay. I'm looking at my colleagues if there's any other questions. I see none. So, and I think Mr. Armstrong, you said you'd rest on your brief otherwise?
Yes, Your Honors. Thank you.
Okay. Thank you, Mr. Dew, both of you, for your arguments. We'll take the case on. I think we're waiting for a little button that says recording.
Yes, yeah.
The case is now being live streamed.
Thank you. So good morning and welcome to the Massachusetts Appeals Court oral argument session for December 1st, 2020. As you know, this argument is being held on Zoom and live streamed on the Appeals Court's YouTube channel. We'll follow the same rules and customs as in the physical courtroom, except you may remain seated if you choose while you're speaking. Once we get going, Mr. Cutting will display a countdown clock in the area where the seal is. Each side, of course, has 15 minutes to argue. There's no rebuttal. Only one advocate will speak at a time. The other one will be muted when it's not their turn. However, please stay on the video so we can see you and know you're still here. And also, since we can see you, please keep your reactions to a minimum because it could be distracting. The proceeding is being recorded and archived, so it's accessible to the public now, and it will be in the future. As always, we've read your briefs and we're familiar with the case. Although you are free to use all 15 minutes, we don't have any penalties if you finish early. So with that, I'm going to call the second case of today, which is Commonwealth versus Corbett, 19P 1439, and Attorney Taylor representing Mr. Corbett.
Thank you, Your Honor. Susan Taylor for Joshua Corbett. May it please the court. Mr. Corbett was convicted of failing to register as a sex offender as a subsequent offender. Under that statute, a level 2 offender like Mr. Corbett is required to register in person every year. If he intended to move, he was required to give 10 days notice. And because he was homeless, he was required to verify his information every 30 days. Under the statute, Chapter 6, 178, Sections C through P, it is a crime for an offender to fail to register, to fail to verify his information, to fail to provide a change of address, or fail to, if the offender provides knowingly provides false information. In this case, the defendant was homeless. He was a level 2 offender. And the evidence that was adduced at trial was that on December the 9th of 2016, he registered in person with the Natick Police Department. He did not, the evidence shows that he did not register on January 8th of 2017, which would have been the 30 days. Detective Arena of the Natick Police sent Mr. Corbett an email on January the 13th, notifying him that he had not timely verified his information. And on January the 18th, Detective Arena received an email back from Mr. Corbett indicating that he was quote unquote stranded in Boston. The other evidence would have been in the case is that the SORB database indicated that Mr. Corbett had not registered anywhere else in the Commonwealth during the month of January.
So I don't get it then. So he's supposed to register in 30 days. He doesn't do it anywhere. How is that not a violation?
Well, the argument is that at the conclusion of the evidence, I don't think that at this defense counsel never disputed that there was adequate evidence for a reasonable trier of fact to conclude with all I'm sorry, I'm sorry.
No worries.
That if you resolve all issues of credibility in favor of the government, that those are the facts, that would have been adequate. But what the Commonwealth at the conclusion of the case basically put forward 3 different views of liability. The first was the failure to verify. The second was the failure to provide a change of address. And the third was a failure to provide a secondary address. So the court listened to the arguments and concluded that there was enough evidence for the government to go forward on those 3 theories of liability. So, and in this case, so all of those, the government was able to argue those 3 violations of the statute. And if you look at the verdict, and I suppose, I don't even think it would necessarily be an issue, but the verdict slip doesn't indicate which theory of liability the jury had to conclude that the defendant had failed to register. So while they certainly, it was utterly reasonable for the jury to conclude that he failed to verify his information within 30 days, I would argue that there was not sufficient evidence for them to conclude that he failed to provide notice of a change of address, because there just simply was not enough evidence of that, nor was there enough evidence to indicate that he had failed to provide a secondary address or even that he had a secondary address. And that error is, I would suggest that that's an error. And if
So are you arguing that it was the Commonwealth's burden to prove whether he was still living in Natick and Boston was a secondary address, or whether he'd moved to Boston? Was that the Commonwealth's burden to prove that?
Well, I think it was the Commonwealth's burden to prove or adduce enough evidence to show that he either had a secondary address and failed to notify them of the secondary address, or that he had moved to Boston. And if he's charged with not providing a secondary address and they haven't proven that he has a secondary address, then how could he provide it? And likewise, if they haven't proved that he moved to Boston, how is it that he violated the statute by failing to notify them that he moved to Boston? And if you couple that with the issue of the instruction that was given by the court to the jury at the conclusion of the case, which was that if Mr. Corbett was planning to move to Boston, he was required to give a 10-day notice to the Natick police that he intended to move. But there was never any evidence that he intended to move. And when the defense attorney asked the court to consider that there was evidence that there was a form that Mr. Corbett went over with the Natick police. And in that form, it said that he's required to give them notice of a plan to move, quote unquote, if possible. And the defense attorney asked that that be included in it, and the court declined to include that in her instruction.
Do we have in the record before us a copy of that form and or any of the requests for instructions made by either the defense or the prosecution?
I did not include the defendant's or the Commonwealth's request for instruction. I did include the instruction and if the court would like, I would certainly go back into the exhibits. I don't think that it was admitted as an exhibit, the form that Mr. Corbett went over with the Natick police, but it was read into the record by the assistant district attorney. And unless the court has any other questions, I will rest on my brief.
Right, seeing that, we might ask to cease to get the copies of the instruction, the exhibits. I think we'll discuss it after the case and among ourselves and issue of some sort of order. We might want to get order together. So we'll hear from the Commonwealth.
Thank you, Your Honor.
Good morning. May it please the court. Kate Simony, Assistant District Attorney for Middlesex, appearing on behalf of the Commonwealth. I was one of the prosecutors at trial. There was overwhelming evidence presented that the defendant failed to comply with his obligation to register with the Natick Police Department by verifying his current information, changing his address, or by providing a secondary address. The defendant's argument is based upon the premise that 178H creates 4 separate, distinct criminal offenses. And I think that misconstrues the statute and the appropriate unit of prosecution. Rather, especially on these facts, the statute, by breaking it apart into sections saying that the defendant's required to verify, to register, and to provide notice of a change of address, the statute merely provides alternate theories that are merely related ways of proving the same crime or legal concept. Here, the defendant's
what theory did the prosecution go on? All 3?
All 3. I think the theory was that the defendant, it was an omission of the defendant. It was a failure to comply with his obligations. And to suggest that the Commonwealth and the trier of fact were also given the extra burden of establishing what the omission was, whether he would have verified his current address or location, whether he would have provided a change of address, or whether he would have provided a secondary address, imposes a burden on the Commonwealth that the legislature did not impose in the statute. What the crime here was that he did not provide any information to the Natick Police Department. It was not dependent on what that information would have been.
So when the Commonwealth proceeds on, if there's a crime that calls for alternate ways it can be committed, and the Commonwealth proceeds on several different theories, does the evidence have to be sufficient on all the theories or on just one of them?
Well, if you look at the cases, including INOA, that break apart the cases on which the evidence has to be sufficient when they're entirely distinct, unrelated ways of proving the crime, and that's not what this statute provides. What this statute lays out are merely alternate theories that are related ways of proving the same crime. If these were, entirely separate, distinct criminal offenses, I think that would be true. But here they are not. To verify registration information per the statute means a sex offender has to come to the police station and fill out the same form, but asserting under the pains and penalties of perjury that the information is still correct. To come in and re-register is to fill out the same form and provide, information, including his location, his address, workplace, all of that. When a sex offender changes his or her address, again, they have to come in, they have to fill out the same form and sign under the pains and penalties of perjury. They're not distinct from each other. And there are obviously, and in any event, in this case, I think there was sufficient evidence to prove that he both failed to come in and that he failed to provide notice of another address that he should have. He was due in on January 8th of 2017, and he did not appear. It was January 18th, 10 days later, that he first indicated by email that he was in Boston. When further communications between him and the detective on January 25th, the detective said, if you're living in Boston, you should register in Boston. And the defendant replied by email saying that he wanted to re-register in Natick and that he still intended to return to Natick. So the only evidence we have that he was not, in fact, at the same address in Natick and just failed to come in was by his own account. So there's certainly an ample basis to have found that he was more than 4 consecutive days or 14 calendar days in a month at some other location that would have required that information to be provided.
Ms. Simony, may I ask, the January 25th email says that he wants to re-register in Natick, not go back to Boston. Doesn't that suggest that he's not in Boston anymore as of the 25th?
I didn't think it said go back to Boston. It was that he didn't want to be in Boston. I'd have to look, Your Honor. But I don't remember it saying that he had to go back to Boston.
Is there a reason why the emails are not in any supplemental record appendix?
No, they were read into the record, so they're clear in the transcript what the substance of them was, but they could have been in the supplemental record appendix.
You would have, if we wanted to see them, between you and Attorney Taylor, you don't have no trouble finding them for us.
Yes, of course.
So I'm looking at page, the second day of the transcript, page 14. The officer, Arena, I guess, is testifying that the email says he wants to re-register in Natick and not go back to Boston. So I'm wondering how there's sufficient evidence that he was, that he ever established a secondary address in Boston, or that he was even gone from Natick for 10 days.
Well, there was, I think, evidence based upon his explanation that he'd been stranded in Boston in any event, as on the 18th, after receiving an email on the 13th and been due on the 8th, that he'd been there for more than 4 nights, saying that he was trying to get funds and trying to get back to Natick. I think there was sufficient evidence, but again.
But is that enough to show that he established a secondary address in Boston?
I think it could be. I think the crux of the case, though, was that he didn't provide any information. And this is why I think it imposes an undue burden on the Commonwealth and the trier of fact to try to determine where the defendant actually was. When the point of the statute is that it affirmatively imposes the obligation on the defendant to provide the required information.
Why is it an undue burden? Why wouldn't it be just simpler for the Commonwealth to say he's got an obligation as a homeless offender to verify his information every 30 days at the Natick police station? He didn't do that. End of case. Without charging these other offenses or other theories about failure to provide notice of a change of address or of establishing a secondary address.
I don't think it was that they were specifically charged as different theories. I think that generally the crime is charged as a violation of 178H, which includes all the information about those 4 different theories. The reason in this case specifically that the instructions to the jury included all of those sections, it did not include the section about providing false information, was that it was clear from both arguments and cross-examination at trial that the defendant was attempting to assert a defense that he had no obligations in Natick because he had in fact moved to Boston. And it would create, as the court found, a different result would in Rosado, that would be an illogical result, that by insisting that he had to only verify his obligations in Natick, he could assert what the trier of fact could be confused into understanding as a defense as opposed to an alternate basis of liability, that he didn't fail to verify his current information, that he in fact changed his address. And if you look at the defense attorney's closing argument, it's clear that that was the defense. And then through his examination of the witnesses, that there was an attempt to suggest that he did not have to go into Natick to re-register or verify because he was not there. And without including those portions of the instruction, it would have been very likely that the jury would have been confused. When, again, the crux of the case and the basis of liability was the defendant's failure to comply with his affirmative obligations under 178H. And to suggest that the Commonwealth would then have to show exactly what the information was, the undue burden would be to require the Commonwealth to establish exactly what information the defendant would have provided had he complied with his obligation to fill out the form. When, again, what the statute imposes is an affirmative obligation for the defendant to supply that information. And as to the second argument made by the defendant, that the jury instructions were also error because they included the portion of the statute that requires that change of address information be provided 10 days in advance. There was no error in the jury instructions. They were correctly based on the law, and they were from the model jury instructions. Chapter 6, Section 178E and Section F.5 do provide that a level 2 sex offender who wishes to move to a different town must provide notice no later than 10 days prior to such a move. Reliance on the Rosado case and the Bowling case is misplaced. The Rosado specifically made clear it was not exempting all homeless sex offenders from complying with their statutory requirements. But however, as here, there was no evidentiary link between his homelessness, his failure to register. There was no way to argue quite plainly that the instructions made a difference in the result of the trial. The defense was not that he didn't register 10 days in advance. He registered 9 days or 8 days or 7 days or, at the time of the move or even after the move. He didn't register at all. The 10 days was completely, it wasn't related in any way to the facts of the case. If he had gone in but it wasn't whether he registered late or only after changing his address. The crux of the case was whether the defendant complied at all in any form with his registration obligations under the statute.
Do we know from this record what edition or what volume of the model jury instructions for use in the district court were used? They're cited in your brief, but there's no year or edition given. And so I know those jury instructions are amended sometimes, and a judge might have an old edition lying around a judge's lobby, or a lawyer might use an old edition. So I don't know how we can figure out what it was that the judge was basing the instructions in the transcript on.
I apologize if the citation was not clear to the version of the model jury instructions. Without having it directly in front of me, I understand that it was the most recent version that, but I didn't cite it appropriately. But in any event, it is completely consistent with the statute, which is, again, what should control. And it was consistent with the direct language of the statute. So
I had a question, which is the defense does not raise this as an issue, but would you say that there's a requirement of specific unanimity on which theory the jury decided, or could 6 jurors say, base it on he moved to Boston, and 6 jurors could say he stayed in Natick, and that would be okay?
There is no question, I think, of specific unanimity. I think here this is of whether a specific unanimity instruction was required, particularly without a request from the defendant.
Yeah, no, I know. I understand that, but just it's an intellectual matter.
So I don't think so. And I think that's for the reasons related to the other issue of whether these were unrelated theories of whether these were just theories or separate, distinct criminal offenses. I mean, here, what was charged was the defendant's conduct. And the conduct was really from a period from January 8th of 2017 through, I think, the date in the indictment was on or about the 18th, where the defendant, his course of conduct was that he did not comply with his obligations. He did not come in and update or provide or verify his information with the police department. It wasn't that there were, again, they didn't have to find whether he was in Boston, whether he was in Natick, whether he was in another town entirely for days or weeks of that time, because again, it was his affirmative obligation to provide that information. He was aware of that obligation, and he did not do it. So if there are no further questions, I would rest on my brief.
Being none, so I think it's likely that the 3 of us will be requesting for you guys to transmit something to us, but we'll let you know. So watch your emails the next couple of days for that.
The case is now being recorded.
Thank you. Good morning and welcome to the Massachusetts Appeals Court oral argument session for December 1, 2020. As you know, the argument is being held on Zoom and live streamed on the Appeals Court YouTube channel. We'll follow the same rules and customs as in the physical courtroom, except you may remain seated while you're speaking if you prefer. Once we get going, Mr. Cutting will display a countdown clock where the court seal is. As usual, each side gets 15 minutes to argue. There's no rebuttal. Only one advocate will speak at a time, and the other one will be muted until it's their time to speak. But please remain on the video so we can make sure you're still with us. And at the same time, keep your reactions to a minimum because that can be distracting. The proceeding is being recorded and archived, so it's accessible to the public now and will be in the future. As always, we've read your briefs and we're familiar with the case. Although you're free to use all 15 minutes, we won't hold it against you if you don't. And with that, I'll call the 3rd case for today, which is Commonwealth versus Ellis, 19P 1329. And for the defendant is attorney, is it Osbolt? Osbolt?
Yes, Your Honor, it's Osbolt. Yes, Thomas Osbolt.
You have the floor.
Thank you, Your Honor. This case, in essence, boils down to the legality of the exit order and the scope of the stop. Mr. Ellis is asking this court to vacate and reverse the trial court's order denying his motion to suppress as a matter of law. To get straight to the point, everyone in the vehicle involved here, including my client, Mr. Ellis, had a reasonable expectation that Officer Manolian would get this traffic stop done quickly so that those detained could go on their way.
So, Mr. Osbolt, if we agree with you that it was an exit order, but we agree with the Commonwealth for one of the other reasons that it offers that the exit order was valid, would it still matter whether the stop was unduly prolonged?
Well, Your Honor, I think it was unduly prolonged up to and including the point of the exit order.
How so?
Well, just taking note of
I mean,
the
if
fact-
the exit order is valid, doesn't that change the calculus about what, whether the stop is unduly prolonged? For example, if there were an objectively reasonable suspicion of distribution of marijuana to a person under 21, does that mean that the traffic stop has to be completed and the gentleman sent on their way as soon as possible, or doesn't that justify a longer stop?
I think the stop from the moment that Officer Manolian arrived at the window, we're unclear at what point he got the license and registration from the driver, at what point he asked for it. He said at some point he got it, but he wasn't sure when. He engaged in questioning not only of the driver, but also of the occupants inside the vehicle. And that's something that's not essentially not permissible under law. There's no basis for Officer Manolian to start engaging in an inquiry with the passengers inside the vehicle, whether he knows them or not. You know, his characterization of this encounter as friendly doesn't really go to how the people inside the vehicle felt in the course of this. And I'd look to Mata to describe that. And essentially with Mata, what we're looking at is whether a reasonable person in Mr. Ellis, Mr. Ulysses, Mr. Betts-Knight's circumstances would believe that an officer would compel them to stay. So this wasn't the case where the officer came up to the window, got the license and registration, talked to them about the purpose or reason why he was stopping them, what the purpose of the encounter was. He starts engaging them in all manner of questioning.
Right. But although what he had in his mind subjectively is one issue, but what's wrong with the Commonwealth's theory that objectively there was evidence of distribution of marijuana to a person under 21, and that reasonable suspicion justified the exit order, and which led to basically everything else here?
I don't think there were any facts in the record that showed that there was any distribution. And I would also say that the statutes that the Commonwealth relied upon in this case require some additional evidence to show that there was some sort of violation. And I'm talking about 94G, 13D. There is no evidence, first and foremost, that this was an open container. Marijuana is packaged in different
Well,
manners.
I'm not talking about the open container theory, which is a civil infraction anyway. I'm talking about the distribution, where there was a smell of marijuana coming from the car when the window opened, when there was a backpack in back with the mason jar with the marijuana in it. There were some empty baggies on the floor. Doesn't that at least create reasonable suspicion that marijuana was being used in the car and that someone had brought it? I mean, they couldn't all three have brought the mason jar, could they? Somebody must have distributed it to somebody else.
I mean,
or at least there's reasonable suspicion of that.
With a license from the dispensary, if they're a registered medical marijuana patient, then they could procure that marijuana on their own. There's nothing that says in this facts and in the circumstance of this fact that any sort of distribution had gone on. I don't think there's any basis on the facts or in the record here to suggest distribution by any means.
And is that something that the Commonwealth needs to negate at the reasonable suspicion stage, or is that a defense?
Well, I don't see where there's any facts at all that support distribution here. I mean, perhaps possession, but possession isn't against the law if someone's a registered patient.
So does the Commonwealth have to assume in a car stop that the person is a registered patient, and only if there's a reasonable suspicion that the person is not a registered medical marijuana user can the Commonwealth proceed as if there's a reasonable suspicion of a crime?
I would suggest that Officer Manolian's conversation with the people involved lends itself to some sort of suggestion or knowledge by him that those involved were not involved in distribution, where Officer Manolian was talking about his brother who was involved in the business of marijuana. So he claims to know these people, doesn't say anything at any point in time about there being any suggestion or hint of unlawfulness to what they were doing with this marijuana. Nothing, not a single hint.
But distribution, you would agree, doesn't necessarily mean distribution to someone outside the car. It can be distribution by the person who brought the mason jar to the scene to the others in the car, couldn't it?
I feel like if we're looking at reasonable suspicion of a crime, there needs to be certain evidence of each element. And there's no evidence that this marijuana was being distributed to anyone at any point in time. There's no evidence that anybody transferred it to anybody. There's no evidence that it was not just sitting in the car when they got there. There's nothing to that. It just invites speculation of all sorts. I don't see how the record supports any of that.
Can I ask you about the door opening? There's at one moment in cross-examination, the defense counsel says to the officer, "So then you open the door," and he just says, "Yeah," and he had previously testified that the driver opened the door. But I mean, does it matter? I mean, for who opened the door to determine whether or not this was voluntary or coercive?
I don't think so, Your Honor. I don't. And that was a mistake that we ended up correcting in terms of an additional motion. When you pause the audio and you played it from a certain point, it makes clear that the officer, Mr. Ulysses had opened the door. So that part doesn't matter in the calculus here, because we're looking at whether a reasonable person in Mr. Ellis's and Mr. Ulysses' circumstances would believe that Officer Manolian would compel them to stay. And looking at those circumstances here, we have blue lights first and foremost. This is not a consensual encounter by any means. They're stopped by the blue lights of the vehicle. That compulsion made itself ever more apparent to the occupants of this vehicle as 2 to 3 cruisers, 4 to 6 officers steadily arrived on the scene as Officer Manolian's questioning continued. Officer Manolian wanted to apparently characterize himself as Father Flanagan and a friendly encounter with the individuals here. But when he left the vehicle with the license and registration, the vehicle was surrounded on all of its, as he called them, cover points. There were 3 additional officers, one at each place behind the car, watching each and every angle. Those officers remained on the scene when Officer Manolian came back and urged Mr. Ulysses to get out of the car. This is a contingent of law enforcement officers on the scene, vehicles that are engaged in an obvious show of authority that any reasonable person would consider coercive or be behavior which would be expected to command compliance. And then when you go beyond these actions and the actual physical setup, Officer Manolian's words and conduct, where he insisted that Mr. Ulysses get out of the car to speak to him, despite Mr. Ulysses' continued, reticence to do that, and Officer Manolian's failure to tell him that he didn't have to get out of the car and speak to him, this objectively communicated that he would use his police power to coerce him to stay.
So let's assume that the exit order was invalid for the moment. That exit order was directed to Mr. Ulysses, not to the defendant. What violation of the defendant's rights led to the discovery of his gun and thus would justify suppression of his gun?
The exit order was part of the unreasonable detention or the unreasonable scope of the stop.
So
here.
let's say that. So let's say that instead of asking Mr. Ulysses to get out of the car so he could have the heart-to-heart talk, the officer had just come back and said, "Okay, I'm giving you a warning. You're free to leave." I'm sorry, losing my train of thought. So go ahead.
I just say that, the Commonwealth kind of wants to have 2 divergent arguments here. One argument goes down the path, hey, this was this completely friendly, cooperative environment. It was this consensual encounter. At some point it turned into a consensual encounter. But then, if that one doesn't work, we're going to say that Officer Manolian was in fear for his safety at some point, which, he didn't really, none of his actions and none of his conduct belayed any sort of supporting of that position. The encounter here, the show of authority never de-escalated at any point. The seizure never terminated after the blue light stopped, but only increased in coercion. And that's essentially where I would rest here, Your Honor. We have the Commonwealth wants to rely on the officer's subjective intent, and the judge did too. The judge did too in coming to this ruling and finding that this was a request to exit the vehicle rather than an exit order, because he had, I think the quote was, a subjective intent and plausible explanation. That doesn't give the Commonwealth an opportunity to skirt the Constitution and Article 14 here.
Let me ask you Justice Sachs's question a different way. Standing. The Commonwealth in its brief raises the standing that your client doesn't have standing to challenge the exit order to Mr. Ulysses. I noticed that you filed a motion for enlargement of time to file a reply brief, but I don't see a reply brief. Is that correct?
I didn't, Your Honor.
Okay, so we have nothing in writing from you, but how do you respond to the standing issue?
Well, Your Honor, I'd say that Mr. Ulysses here was subject to the excessive scope of the stop that culminated in the exit order and pat frisk of Mr. Ulysses here. He was subject to the constitutional violation. He has standing here, is essentially would be, you know, my reply, and I could respond to that. You know, I apologize for not, you know, following up with my reply brief. That is my mistake, and I own that. But I would say the standing here is clear in terms of the constitutional violation that Mr. Ulysses, or Mr. Ellis was subject to.
I have a question, and this is kind of back to some of what you were discussing with Judge Sachs. What if you had an incredibly naive police officer who's a Barney Fife police officer who thinks good of everyone, and he does not perceive subjectively that there's a reasonable suspicion that the people in the car are distributing or have distributed marijuana to someone under 18, but an objective police officer would. And that's why the other police who arrive at the scene are taking up these points and using their blue lights, etc. Does that help you at all?
I would say that any sort of inkling of or hint of danger was dispelled as the encounter went along. You know, every opportunity that Officer Manolian had to gather additional information from the individuals involved here showed only cooperation, compliance, and friendliness, as he testified to. And in those circumstances where a reasonable officer is encountered with people who are compliant, who are cooperative, who are friendly, who are obliging in essentially every way to increasing questioning, increasing requests in terms of being asked to search a bag, there's no hesitation, there's no signs of nervousness, there's nothing that would show here to an objectively reasonable officer that there was a reason to fear for his safety.
Although can you, I mean, again, it's kind of circular, but can you order, an exit order could be justified by reasonable suspicion of a crime, right?
Yes, Your Honor.
And does that reasonable suspicion need to be targeted at the driver, or can, if there's reasonable suspicion that anyone in the car committed a crime, is it permissible to order the driver to exit?
I'm not sure of the answer to that. I'd say here there's not reasonable suspicion, so it would be kind of an academic exercise. I'd say there isn't that reasonable suspicion of a crime here, but I expect that it would be justified to order, but I don't know is my answer, to be honest.
All right. Any other questions? You have 17 seconds. You're free to sum up, or we'll take it from here.
I just say here, you know, this is a case where there's not the evidence that was necessary here. The judge acknowledged that, essentially, I would argue, in his findings. So he tried to find a way to sustain this on different grounds because there wasn't an objectively reasonable suspicion of danger.
Thank you.
Thank you, Your Honor.
We'll hear from Attorney Pell.
Thank you, Justice Massing. Good morning, and may it please the court. Gabriel Pell, Assistant District Attorney for Middlesex on behalf of the Commonwealth. And I think the key thing here to understand is our position is that Officer Manolian's conduct was at all times objectively authorized and reasonable. We might sometimes refer to what his subjective intentions might have been, but at the end of the day, make no mistake, our position is that it's the authorization rule, and we look to the objective authorization. and also where there's discussion about the length of the stop, I think it's important to emphasize that the record indicates this whole interaction took about 10 to 15 minutes, which means we're going to spend more time talking about it today than it took at the time. And I hope that as my brief shows, under the authorization rule, there are about 4 or 5 different ways you can look at this interaction to affirm the motion judge's ruling. And I stand by all the legal arguments we made about standing. And to be clear, it's not distribution of marijuana. The crime at issue is furnishing marijuana to minors. So in fact, my position isn't even that you have to suspect any of the occupants of the car of criminal activity, but rather that they had evidence of someone else's criminal activity by which they obtained the marijuana. But I think
Is that a ground for an exit order? If none of the individuals in the car are reasonably suspected of criminal activity?
I think it is, Your Honor. I think one way to look at it is if you have evidence that a crime has been committed in terms of furnishing marijuana to the minors, the marijuana in the car is itself evidence of that crime. So you have probable cause, if you want, objectively, to search the car for more marijuana, which is more evidence of that crime, especially where you have the baggies.
I just want to make sure I'm understanding. You said probable cause. You're off of reasonable suspicion now?
No, Your Honor. Again, it's this branching analysis. So one would be probable cause that you could search for evidence of the crime and order everybody out of the car out to facilitate that search on a PC level. But you also have reasonable suspicion of the criminal activity. You asked, does it have to be individualized to the driver or the passenger? The case law sometimes speaks of reasonable suspicion of criminal activity. You have that here. They might know something. They could each be ordered out individually.
Well, sometimes the case law is more specific and it's not always clear why. So what's the theory on which reasonable suspicion of criminal activity somehow associated with the car permits an exit order to any given individual in the car? And here, since the exit order was to the driver, let's focus on the question, what sort of reasonable suspicion of criminal activity justifies an exit order to the driver?
And I think the guiding point here is proportionality and reasonableness. So if you had reasonable suspicion of a furnishing of marijuana crime to minors, you could order the driver out because you wanted to talk to him to investigate as a threshold inquiry into who might have provided the marijuana to these minors. You would be permitted to question him separately from the other 2 passengers to prevent collusion in the answers. But I want to take a step back because, again, I stand by these theories. They're legally valid. I think they're intriguing. But the shortest distance from here to the affirm, I actually think, is to first assume for the sake of argument that the defendant has standing to challenge his driver's exit. Again, I don't want to concede it, but the shortest distance. Second, assume further for the sake of argument that the exit is the product of an exit order as opposed to an exit request. Again, not conceding it, but if you make those 2 assumptions, the shortest distance to the affirm is then to do a straightforward officer safety-based exit order analysis, the conclusion of which shows that an exit order would have been justified, even if that's not what was in Officer Manolian's subjective intentions at the time. And I could go through the step by step. I can also answer the court's questions. I do just want to say at the outset, one more housekeeping thing, if I could, to Justice Massing's question of my brother about the opening of the door. We do have before the panel a joint motion and stipulation to correct the record. One of the things that would correct if the panel accepts it is a transcription error on page 53, where it said, and at that point you said you opened the door. It's really at that point you said he opened the door. And once you correct that error, I don't believe there's any basis in the record, not in the 2 attorneys who are pursuing the motion for Ulysses and this defendant, their questioning or argument, the prosecutor, the judge, even the defense witness, nobody else mentions that the officer opened the door.
Right. No, I understood Mr. Oswald to be conceding that.
Okay. Thank you. Sorry to belabor that. So, and I think the way that you analyze this is incrementally, the way we would any suppression issue is, was the officer's conduct such that it needed constitutional justification at any point? And if so, objectively, did he have it? So we've got the stop. There doesn't seem to be any basis to challenge it. It's an inspection sticker. And beyond that, actually, I don't dwell on this in the brief, but as the stop goes on, it looks like it includes illegal dark tint as well. Then the officer approaches the car and he's making that initial conversation. And contrary to what my brother is arguing here, there is no bright line rule against making conversation with the occupants of a motor vehicle in the course of a car stop in general, let alone where the officer actually knows the people. In 2010 in Commonwealth versus Mathis, This court quoted the Supreme Court's decision in Arizona versus Johnson for the proposition that general questioning unrelated to the reason for a police encounter does not convert the encounter into something other than a lawful seizure, so long as those inquiries do not measurably extend the duration of the stop. A few years later, in 2017, in this court,
if we find that the exit order was valid, do we need to reach any issues about prolongation of the stop?
I think, to be fair, based on the framework that I'm suggesting, is you look at it at each point. So if the defendant were correct that this conversation shouldn't have happened to begin with, and that precedes the exit order, we'd have to make sure that the conversation didn't taint anything that happened later on down the line, in fairness. And I think one of the things you'd ask there is, one, does he need constitutional justification to make conversation? The answer is no. Again, in Commonwealth versus Martin, you have someone suspected of only a civil marijuana violation, and the officers ask him about his criminal history. And this court said, well, the questioning produced no incriminating evidence and was brief. So here, and context is important, especially in these police-citizen encounters. The conversation was totally reasonable. And by the way, it didn't materially extend the stop or produce any evidence that leads to the discovery of the guns. Officer Manoulian knew all three of these people. Ulysses offered up his own Snapchat. And frankly, it's just kind of absurd to suggest that an officer can't check in with a gunshot victim he accompanied to the hospital within the past couple weeks, which is this defendant. So if he wants to ask him how his arm is, that's a commendable example of community policing, as is checking in with a teen. This is now the front seat passenger, Mr. Betts Knight, who he knows has a history as a runaway and he hasn't seen in a while. So there's no prohibition against this. It's reasonable, especially in the circumstances, and it's brief. Mr. Betts Knight testifies that he says this whole initial interaction is about 2 seconds. Officer Manoulian puts the whole initial interaction, including the backpack search that I imagine we'll talk about, at 2 minutes. So it's brief, it's permissible, and it doesn't lead to anything that leads to the guns.
Why did Officer Manoulian need to get the driver away from the other passengers to talk about the expired inspection sticker and whether or not he was going to give a ticket? Is that something so confidential or private?
So what Officer Manoulian explains at the suppression hearing is that in his experience, people like Mr. Ulysses behave differently when they're kind of surrounded by their friends than they would in a one-to-one interaction. And what he wants to have the heart-to-heart is to say, pull the tint off your windows, get the car inspected, stop drawing police attention. Look, I don't think we rely on that because, again, that's more about Manoulian's subjective intention. I think the point for the standing argument, if we want to go down that route, again, we don't need to for the shortest distance here, but is that he was permitted to give a warning, and he can give a warning that he thinks is meaningful. So I think in the transcript, he says that warning might have taken about 30 seconds. I think he might be underplaying it there, but the whole interaction with Ulysses and the back and forth of will you step out, Manoulian estimates, he says it's about a 7-second interaction tops. So from this defendant's perspective in the back seat, his interest is the length of the car stop. It is not materially extended by Manoulian trying to deliver his warning in this way. And again, we don't need to go, we can look at it as an exit order, either based on the objective evidence of a marijuana furnishing crime to minors, either on the PC or the reasonable suspicion, but we can also look at it as an exit order for officer safety. And the first thing to remember when we're doing the officer safety analysis is what's been repeated in the case law, is it does not take much for a police officer to establish a reasonable basis to justify an exit order based on safety concerns. The SJC has said this in Stampley, quoting Gonzalez, and it's a lenient test, it's a minimal threshold. And again, while Manoulian's subjective motivations do not control, I think it's worth noting that, yes, he was familiar with the people in the car, he did try to engage them, but what the record shows is that his approach throughout was a hybrid of caution and engagement. So at the outset, he calls for backup when he sees it's Ulysses' car. He searches the backpacks and it was consensual, and I can talk about that, it's in the record, but from his perspective, it was for safety. He finds the side-to-side movement of the car and the defendant's hand movement concerning. So then step back to the objective analysis, and you have the driver's record, which it wasn't impounded below, and our briefs aren't impounded, but I know we're live streaming, so I'll just say, look, if you look at the record in the brief for what Manoulian knew about the driver, also his apparent probation status based on the bracelet, the gang affiliations of everybody in the car, all three people in the car were believed to be associated with the Maplewood gang, And that gang, in turn, is apparently involved in drug distribution, robberies, firearms, violent crime. And again, I'd ask the court to consider the extent to which that may or may not overlap with what Officer Manolian believed he knew about the driver. And although Officer Manolian uses the term affiliate, and we don't really know what he means by that, they don't have to be gang members per se for it to matter for the reasonable officer safety concern. In this court's decision in Graham in 2010, the court reasoned that if you know that passengers in a car are associated with members of a local gang, that's among the circumstances establishing reasonable safety concern. But this isn't just some kind of theoretical thing where these people had their names end up on a database somewhere. The defendant himself in the back seat is a recent gunshot victim, which would further suggest an ongoing active feud, or at the very least, a reasonable inference that he and or his companions had armed themselves for retaliation or protection. Then on top of that, you've got the multiple suspicious movements in the car. The side-to-side movement in a car with tinted windows that, similar to the movement that this court in Ellis said, can be indicative of attempts at concealment, and the defendant's hand motion after he's told not to make sudden movements. And we don't isolate these factors and examine them in isolation. We view them as a whole in the totality of the circumstances. So what do we have there? We've got multiple ambiguous movements in a car with 3 gang affiliates who are inferably armed in the wake of a recent shooting.
So just moving away from the officer's safety potential justification for the exit order and back to the marijuana, your brother says that there was no evidence that this marijuana wasn't possessed as medical marijuana. What do you say to that in terms of the reasonable suspicion calculus? Must there be reason to suspect that it is not possessed for medical purposes?
No, I think that on any reasonable suspicion, or even if you want to elevate to the probable cause standard, officers don't have to eliminate any possible innocent explanations. And here what you have objectively, again, and the crime at issue being furnishing, is 3 gang affiliated youths in a car with empty baggies, a mason jar with marijuana, not necessarily how I would imagine, at least, you get it when it's prescription. But even so, they don't have to eliminate those possibilities. If it's reasonable suspicion and we're talking about a threshold inquiry, that's certainly fair game for the questioning. Again, you could order out the driver and say, where'd you guys get the marijuana? If he says medical marijuana, maybe it changes the contours of it. I'm just going to confess, I don't even know if they're prescribing youths medical marijuana. But again, you wouldn't have to negate that for the reasonable suspicion, especially given the overarching context of the Maplewood gang, their involvement in drug distribution, the empty baggies, the mason jar, what they know about the odor of marijuana in the car where you have 3 different people. Again, it's reasonable suspicion. It's not probable cause. It's certainly not beyond a reasonable doubt.
I understand that we're supposed to look at it from an objective point of view, but yet it seems like the officer, any subjective officer safety concerns he has, he dispels along the way. Isn't that relevant to the reasonableness of an officer safety concern?
I think the first point is that he doesn't dispel them along the way. He takes certain steps, but if you take the side-to-side movement in the car, this court in Ellis recognized that could be evidence of concealment of something. The fact that when he checks the backpack, he finds only marijuana doesn't mean that the side-to-side movement wasn't somebody concealing a weapon under a seat or in a pocket or tucking it into their waistband. And we see that, I think it's Commonwealth versus Goey, is someone might be going for a cigarette if you then see them smoking a cigarette, but they might have also been going for something else. And so they don't have to give the benefit of the doubt. They don't have to comfort themselves with possible innocent explanations or gamble with their safety. And it is a mounting thing. And what the SJC recognized in Stampley is not acting right away on the first possible sign of danger is actually a good sign, because it means they weren't just going on a hunch. He's waiting objectively. They could wait till it all kind of comes together. And when he comes back to the window, when it's still within his discretion to cite or warn, if objectively, if he'd wanted to at that point for his safety, based on everything he knew about them and everything he had seen so far, an exit order would have been justified. You can also, like I said, there's the alternative. You could look at it as a consensual exit. And the issue under MATA, I can't be more clear about this, is it's not whether they were free to leave. It's whether, even under the reformulated standard, it's not whether they would have been compelled by the blue lights.
But don't you think where they were stopped with the blue lights, he's still got the license and registration. doesn't that objectively, he's saying, please get out. Will you get out? Doesn't that objectively communicate that he's not going to allow the driver to leave?
Well, but it's not about objectively communicating whether he'll allow the driver to leave. It would be objectively communicating that he's going to use his police power to coerce him to comply with this request, the exit request. He obviously can't leave. That's correct. But the same way, like, you know, I don't say this in my brief.
Isn't that kind of slicing it pretty fine? I saw in your brief that you said, well, you don't look at whether he's free to leave. You look at whether he's free to comply with the, or whether it's objectively communicated that he's not free to comply with a particular request. What case supports dividing the interaction up into such thin slices?
I see that I'm running out of time. If I can just answer the question. So I think the way to look at it is twofold. One, and I don't say this in my brief, but the Supreme Court decision in Florida versus Bostic, it's a bus passenger. And what the court analyzes is that he's asked for a consensual bag search. And the idea is, well, he's a passenger on the bus. So it's not about whether he would leave because he wants to be on the bus. He wants to go where the bus is going, but whether he can decline the luggage search. And I think then the best analogy then from that is any consensual search. And I know we missed a chance to talk about the backpack search in this case, but in a car stop, in a civil infraction, Commonwealth versus Buckley, Commonwealth versus Ortiz, civil infractions, if you ask to do a consensual search, the question there isn't, is the officer going to coerce you to stay? Because the traffic stop's ongoing, so you're going to stay, but are you free to decline the request to search your bags? That's the more appropriate analysis. So here by analogy, you're not going to leave until the traffic stop's concluded, but are you free to decline this request to exit? But again, we don't have to rely on that. We can do the objective safety factors.
Any other questions? All right, thank you both for your arguments. Really a top-notch advocacy from both of you. Thank you very much, and we'll.
Case is now being recorded.
Thank you. So good morning and welcome to the Massachusetts Appeals Court oral argument session for December 1, 2020. As you know, the argument is being conducted on Zoom and live streamed simultaneously on the Appeals Court YouTube channel. We'll follow the same rules and customs as in the physical courtroom, except you're free to remain seated if you prefer. Once we get going, the clerk will display a countdown clock. Each side has 15 minutes to argue. There's no rebuttal. Only one advocate will speak at a time, and the session clerk will mute the other one until it's your turn to speak. But remember, we can still see you, and we want to be able to see you to make sure you're still with us. But please keep your reactions to a minimum because that can be distracting. The proceeding is being recorded and archived, so it will be accessible to the public. As always, we've read your briefs. We're familiar with the case. Although you're free to use all 15 minutes, there's no penalty for finishing early. So calling the fourth case of today, 2020 P152, Field versus Field. And for the appellant, Amy Field, is Attorney Duffy.
Thank you, Your Honor. May it please the court, I'm Peter Duffy for the appellant, Amy Field. This is an appeal of a judgment of the Middlesex Probate and Family Court that adopted a special master decision in a divorce case. More specifically, we appeal from a pretrial decision of the trial judge, which was Judge Gargis, finding that certain proceeds of a loan the husband fraudulently obtained using a forged notarized signature were used for joint or marital purposes, despite the lack of documentary or other evidence to show that the monies were used in connection with the marital enterprise. We would submit that the trial court committed error because it effectively imposed the burden of proof on the wife, who was the victim of the fraud, to show that the monies her husband borrowed using the forged signature of the wife were used for the joint or marital purposes, rather than imposing the burden where it belonged, which was on the husband, who was the perpetrator of the fraud, to show that the monies were used for a marital purpose.
Can I ask you a couple of threshold questions? Does it make any difference if we're, I mean, it's the judge adopted the special master's recommendation on this. So does it make any difference whether we consider it, whether we're reviewing the judge or reviewing the special master?
I think it matters if you're reviewing the, I do think it matters somewhat in this case in particular, Your Honor, because we actually do have a motion to strike certain materials that are included in the supplemental appendix that was filed by the appellee. And they were materials that were apparently submitted to the special master, but never worked their way to the judge. So the judge, in making her decision to adopt the special master's decision, actually did not have the benefit of that record. And there really wasn't an adequate basis for the trial judge to make the decision that she did. In fact, counsel, by submitting the supplemental appendix to submit these additional materials that never actually worked their way to the trial judge, was effectively conceding that the trial judge didn't have before her what was needed to make the arguments and make the case that the appellee wants to make. The rules of appellate procedure.
I have a question. I understand you want us to do a de novo review of the special master's findings because the special master only considered documentary evidence. How can we do that de novo review without seeing the documents that are in the supplemental record appendix, including the home equity documents from February of '06?
I would submit, Your Honor, that you would be conducting a de novo review of the trial court's determination. And you would look at what the trial court had before it by way of documentary evidence. And the trial court did not have sufficient documentary evidence. But I would submit, though, Your Honor, if the court were inclined actually to conduct its de novo review at the special master level rather than at the trial court level, I would submit that even if the court considered the materials that should be stricken from the record, those materials don't make the requisite connections that the appellee wants to make. And more specifically, the appellee relies very heavily on what he calls an accountant note, or what the special master calls an accountant note. And the theory is that this accountant note somehow proves that money's flowed from the home equity line to the party's joint Bank of America account. But the accountant note says no such thing. In fact, if you look at the accountant note, it actually supports the opposite inference. The accountant note says that the monies were actually held for investment. And so that wasn't going into the joint account. And then in an attempt to buttress this argument, again, this is materials that were not included in the trial court record, counsel submits a Bank of America account statement. He says that it was from the end of 2009, but if you actually look at the statement, his brief says it's from the end of 2009, but it was actually the statement from the end of 2008. And the theory is that because that essentially shows about $90,000 in the Bank of America account, that somehow lines up with the accountant note, which also says there was 90,000 remaining. But what he misses is that he's got the dates wrong. The 90,000 is stated to be by the accountant at the end of 2009 going into 2010. The bank record he looks at is from 2008 going into 2009. But in any event, the Bank of America statement that he shows that it's an operating account of the parties. It's not an investment account. So this is quite different than what the accountant note says. Moreover, when you look at that Bank of America statement, it actually shows that it's just an operating account of the parties. They basically, you see the husband's paycheck being deposited into it. So there's no reason to believe in the record that this actually is an account that received the monies from the HELOC account. There really is no connection that's been made by the special master or by the trial court to actually show that the expenses that the husband's claiming were paid out of the HELOC account were really paid out of the HELOC account. And that's my fundamental problem with both the special master and the trial court, is in the absence of that evidence, the special master and the trial court essentially decides that they should find in favor of the husband because there aren't bank records that exist. But really, in the absence of evidence, the decision should go against the party on whom the burden of proof is placed. And the burden of proof in this case is placed on the husband. Now, to be sure, the special master does say that he's imposing the burden of proof on the payor, which would be the husband. So he nominally acknowledges that that is the correct legal burden of proof, or party who should bear the burden of proof. But then his decision itself And the rationale he gives is completely against that. He imposes the burden on the wife. But Your Honor, we would submit that actually by placing the supplemental appendix in the record with these materials that never worked their way to the trial court, it actually does show that the trial court judge certainly made a mistake when she decided both to adopt the special master decision and she decided to preclude any further evidence on the issues from being presented at trial. Now, my brother criticizes us for not placing the memorandum of decision, the post-trial memorandum of decision, into the appellate record, as if that decision had some bearing on the trial court's determination to adopt the special master decision. It had no bearing on it. The trial court actually, it was before trial. The trial judge had already decided before trial that she was not going to consider evidence and that she was going to adopt the special master decision. So she did not consider the factors in Mass General Laws 208-34 in making that decision. Judge, the special master is clear that he did rely solely on 5 documents in making his decision. And because this is based solely on documentary evidence, I would submit that this is a matter that does call for the application of the de novo standard of review on an appeal. But even if the court were looking solely for legal error, there was a legal error. And the legal error was to improperly place the burden of proof on the wife rather than placing the burden of proof where it belonged on the husband. And there are many reasons why the burden of proof should be on the husband. First and foremost, because this action is predicated in a fraud, where the husband.
I have a question for you about your use of the word forgery.
Yes.
I understand that the husband has admitted that he signed the wife's name to the home equity line of credit documents back in February of 2006. Has any judge or special master or tribunal made a finding that in doing so, he had at the time in February of 06, an intent to injure or defraud anyone or an intent to permanently deprive the wife of the funds?
Where that is in the record, Your Honor, it's in the colloquy that was before Judge Aber.
When he appointed Attorney Mayer as special master.
That's right, correct. And at that point, it's quoted in our brief, Your Honor, and he does say that it was notarized fraudulently. And then even the special master then said, the second loan, that's the fraudulent one. So that was the predicate for the entire.
Well, I saw those words, but I also see that he's using the HELOC to pay off the prior HELOC. He's using the HELOC to pay wife's medical expenses. So it raises the question for me whether this was actually without the knowledge of the wife and meant to defraud the wife.
Well, Your Honor, there is some evidence in the record that was presented that there was the payoff of the pre-existing equity line at the time this equity line was taken. There is not evidence in the record other than just bald assertions that are contained in the appellee's papers and in the letter submission that went to the special master, that the medical expenses of the wife were paid out of the HELOC. That connection actually has not been made, Your Honor. It's not lined up that there's a connection between the HELOC account and the payment of medical expenses. What you would need to show is that there was a transfer of monies from the HELOC account to the bank account out of which medical expenses were paid. And that's the critical gap that's missing here. There's no documentary evidence of that. In fact, actually, I don't even think that the special master actually finds on that point against the wife. I think the expenses that he charges against the marital estate don't include the medical expenses. But that's the critical issue, Your Honor, is that the proof just doesn't exist that monies flowed from the HELOC to an account out of which these expenses were paid, and certainly not on the medical expenses.
So the accountant's note, which is in both your papers and in the supplemental appendix only, the one in the supplemental appendix you can actually read, it does mention the 200, like basically emptying out the home equity line because there was some, I guess, some threat. So elsewhere in the record it says some threat of it being closed out. I mean, do you contest that it was actually emptied out and for whatever purpose?
I actually do contest that, Your Honor. It's actually and I can show you that it actually was not closed out when it was claimed to be closed out. If the court would go to, I can get you the site in one moment. It would be in the supplemental appendix, but these documents also appear in the regular appendix. But if you see on page 107 of the supplemental appendix, there is a check at the top of that page, which indicates a payment of slightly in excess of $4,212, and it's coming from Sovereign Bank. And if you line that up against the special master's decision, you will see that that's one of the expenses that he's charging against the marital estate. So that's coming out of Sovereign Bank. That's not coming out of Bank of America. So the Bank of America account certainly did not receive all of these monies. More importantly, on that accountant note, it says that the monies are being placed in an investment account. And there's no evidence that this money's been placed in an investment account. In fact, when counsel for the appellee points to something he claims is proof of that.
It doesn't say, I'm sorry to interrupt, but it doesn't say in an investment account. It says is 80,000 or 90,000 remains in an account solely as investment. So
Correct.
What that suggests to me is it's just sitting there. It's going to earn something, whether it's interest or dividends, depending on how it's invested. That doesn't necessarily suggest to me that it was moved out of wherever the HELOC proceeds originally went, which the master found was the Bank of America account.
I appreciate the distinction Your Honor is making, but if Your Honor looks at at the only proof we have concerning the nature of this Bank of America account, if the court's inclined to consider it, it would be in the supplemental appendix. It's at page 129, and you will see that that's where he says the 90,000 was. And again, he's got the wrong. He says that this is as of the end of 2009, but he actually gives a statement for the end of 2008. But in any event, this is certainly not an account where monies are just sitting, where monies have just been placed. If you look at this account, this is actually an operating account. The husband's paycheck actually is going into this account. The family expenses are being paid out of this account. This is not something where something sitting around as an investment. These monies, if they were placed in this account, and I don't think there's any proof they have been thoroughly commingled in a way that the special master has not even attempted to tease out which monies originated with the HELOC and which monies didn't. I do see my time has expired. I can continue if the court wishes, but otherwise I want to respect the clock.
Thank you. Any questions?
Your Honor.
Okay, thank you. We'll of course we'll rely on your brief for whatever we didn't get a chance to get around to.
Sure.
Attorney Hamilton.
May it please the court, Terry Hamilton for the appellant, Matthew Field. I think the court here has two avenues, two different avenues or approaches to determine the outcome of this appeal. The first one, and I think the one that the court ought to take, is via Rule 53H3, which says that the court shall not review any findings of a master that raises a question of law unless there is a transcript of the evidence before the master. And it's quite plain here that there was no stenographic transcript before the master. And what the appellant is raising here are two questions of law. Number one, he's raising the sufficiency of the evidence that was before the master. And number two, he's raising the question of whether the burden of proof was properly applied.
Listen, doesn't that Rule 53 H3, I mean, isn't that applying commonsensically to evidence that was taken by testimony as opposed to documentary evidence?
I don't think the rule reads testimonial or documentary, but I think it implies by the fact that it's a stenographic transcript that it would certainly include testimony.
What purpose would it serve to shut off review here because there's no transcript of a hearing that never occurred? In other words, wouldn't a literal application of this rule lead to an absurd consequence?
I don't believe so, Your Honor, because one of the cases that I cited in the opposition to the motion to strike, I believe it was the Shelburne Shirt Company case, the court said it would serve little purpose to refer questions of fact to a master if a party, after adverse findings, could go back to the trial court or even to this court upon appeal and have the trial judge or the appellate judge go back through all of the evidence. It's a matter of judicial economy. And so therefore, I believe that why the real rule is written, and that ought to be the way that the rule is applied. Secondly, that's obviously the shortest distance to decide this case. The other one, of course, is to look at the sufficiency of the evidence. And in this particular case, the appellant is asking this court to look at the sufficiency of the evidence. But the appellant is doing that without providing this court with the entirety of the evidence that was before the master.
Well, let's assume that we accept your supplemental record appendix and we look at the various accountants' notes and the Bank of America account. I have two questions about the link that the special master drew between the HELOC proceeds and the Bank of America account. One is the accountant note refers to the remainder of the HELOC proceeds going into an account. It doesn't say a joint account. It doesn't say Bank of America account. It seems to be kind of a leap. The second thing is when you try to strengthen that connection or when the master did, by pointing to the balance being 90,000, as your brother stated during his argument, there was 90,000 in remaining proceeds from the HELOC account, and then a year later, or perhaps a year earlier, a similar amount was in the Bank of America account. But that seems perhaps like a fortuitous coincidence more than a demonstration that that's where the proceeds of the HELOC went.
Well, first of all, Your Honor, let me say that if you trace all of this through the accountant's notes, it does establish a line of evidence, whereas back in 2006, and just let me stop right there for a minute, because we're talking about a HELOC loan that was taken out in 2006. We're talking about a divorce that began in 2013, and it was not until 2015 that the wife raised any objection.
Yeah, well, we understand there's some records missing, but let's go with the ones that we have, and how do they support the notion that the 90,000 or whatever from the HELOC went into the joint account?
The only documentary support, unfortunately, again, because we're talking about banks only keeping records for 7 years, is the $90,000 that shows up in the account at the end of 2008 and 2009. But it's also clear from the accountant notes that number one, the HELOC was taken out in 2006. In 2008, when we had the Great Recession and banks were starting to close down lines of equity, the Fields decided that they ought to take that money out, put some of it in a joint account, but also make expenditures that we did have records for. And Mr. Duffy was referring to page 107 of the supplemental appendix, and that shows a series of checks. And those checks clearly establish that the money from the HELOC was spent on a home improvement project, which I believe was $70,000, $80,000 in itself. Perhaps the more interesting aspect of those checks that are set forth on page 107 of the supplemental appendix is the fact that two of them were signed by Amy Field. They're alleging fraud, but yet we have Amy Field taking advantage of the HELOC that she now says was fraudulently obtained. That simply does not make any sense. It certainly doesn't wash. Her signing of those checks is clearly a ratification of the fact that she knew the HELOC existed. She knew she had given permission to her husband to sign her name to it.
So those checks, those checks on 107 are from the HELOC?
That is correct. It's drawn on the sovereign bank and the HELOC.
Okay, so I mean, 108, 109, 110, those are all dated in 2012. I thought that it was depleted in 2008.
I don't believe that it was completely depleted. Or there may have been another transfer, which unfortunately, again, we don't have a record of, back to Sovereign in order to make payment for those home improvement projects that the Fields jointly made.
Can I ask, you make the argument, didn't follow, but maybe you can clarify for me. What do the Section 34 factors have to do with the issue of tracing the money from this particular account?
Number one, the Section 34 factors are important here. Number one is a matter of procedure. Under Rule 18 of the Rules of Appellate Procedure, a party is required to include in the record appendix the findings of the court. And this was the
relevant findings made by the master.
Pardon?
But weren't the relevant? Is there anything in those 30 pages of the judge's rationale that elucidates the judge's decision on the special master's report?
Not particularly, Your Honor, although within those 30 pages, she does note the adoption of the master's report. But if you review the cases that have come down from the SJC and your own court, the distribution of the money under the HELOC and the assignment of it to marital purposes and or non-marital purposes plays into the division of the marital assets. And the courts always look at the total division of marital assets when they're looking at a particular distribution or a particular division of an individual marital asset. And I think one of the cases that I cited, Williams versus Massa, that was a case in which the appellant challenged a number of the decisions that were made concerning the division of the marital estate. And in doing that, they looked at the entirety of the court's findings, rulings, and rationales in order to determine that these were fair and equitable divisions of individual pieces of property. So what it does, Your Honor, is that it provides context to the court when they're looking at the allocation of the HELOC. It gives them context to see how the court, how the judge in this particular case, made distributions of a number of marital assets. And this was a fairly large estate. There were a number of different items of property, a lot of different assets and liabilities that had to be distributed.
So if we were to find that the evidence, there was no evidence to support the special master's finding with respect to this $75,000, where would that money go?
I'm sorry, I'm not sure I understand your question.
The special master said, okay, we got $350,000. I say 228 or whatever of it is marital property. The other 100, whatever, the husband took. And did the judge make the husband pay that back all to the wife?
Yes, yes. As a matter of fact, when the court adopted the master's order, she said the 228,000 were for marital purposes, and the remaining, I believe the number was 121,000, would be paid by the husband to the wife. The interesting thing about that, Your Honor, is that in the court below, we took the position that almost the entirety of the $350,000 went to marital assets. But unfortunately, a lot of that money was spent in 2007 and 2008 for different medical procedures that the wife had. And unfortunately, because of the passage of 8-10 years, there were no records for that. So that was an example of where the master found that he did not have enough evidence in order to attribute those expenditures to the marital estate.
Right.
And
So,
whereas opposed to the ones that he did.
Let me get back around to my question then. So if the master had found there were another 75,000 that were not accounted for as marital property, would that also be owed from the husband, all of it to the wife, or would that be subject to the division under the Section 34 factors?
Well, I think if this were to be remanded, this would have to be looked in the entire context of the division of the marital property. So it would raise all of these questions all over again. In conclusion, Your Honor, I would say that the special master here not only did the correct thing in looking at the evidence based on the evidence we had, and once again, there was a paucity of record. But the other interesting thing here is that when the wife challenged the original findings, the judge sent it back to the special master for a second time. So this got a second look. It got a second argument. And the master, in looking it over again, came to the same conclusion, that the expenditures that were attributable to the marital estate were legitimate, were backed up, and therefore this court ought to affirm that finding. Unless you have any further questions, I see that my time has expired, and I thank you.
Okay, yes, seeing none. Thank you, Mr. Hamilton. Thank you, Attorney Duffy. We'll get going.
case is now being recorded.
Thank you. So good morning and welcome to the Massachusetts Appeals Court oral argument session for December 1, 2020. As you know, the argument is being held on Zoom and live streamed on our YouTube channel. We'll follow the same rules and customs as in the physical courtroom, except you can remain seated if you prefer. Once we get going, the clerk will display a countdown clock. Each side has 15 minutes, no rebuttal. Only one advocate speaks at a time and the other one will be muted. But remember, we can still see you and we want to see you to make sure you're still with us. By the same token, please keep your reactions to a minimum because that can be distracting. The proceeding is being recorded and archived and will be accessible to the public. And in that vein, this is an impounded case, so we'll refer to pseudonyms instead of the names of any real names. And as always, we've read your briefs and we're familiar with the case. So you have 15 minutes, but you're no penalty for finishing early if you're finished early. The case is 19P 1638, John Doe number 523671 versus Sex Offender Registry Board, and Attorney Doherty representing John Doe.
Yes, good morning. May it please the court. I am Elizabeth Doherty and I represent the petitioner John Doe in this case. Mr. Doe was classified by the board as being a level 1 sex offender, a low risk sex offender, despite the fact that he has been, at the time of the hearing, had been offense-free in the community for 23 years or so, and based on offenses that had occurred well over 27 years ago. But once a sex offender, always a sex offender, at least the board and the hearing examiner would have you conclude. Today, I would like to address two of the issues in my brief. Both, first of all, the failure of the board to meet its burden of proof to establish that Mr. Doe was, in fact, a level 1 sex offender and required to register. And then also the second issue would be the denial of expert funds for an expert. Getting back to the first issue, there are, in the hearing examiner's decision and also the Superior Court judge's affirming of that decision, there are several problems as I see them. First of all, the decision is basically, the hearing examiner relies solely on the characteristics of the offenses that occurred 27 years ago as a basis for her decision.
I have a question about that. It seems
Sure.
to me that hearing examiner gave extensive consideration to the mitigating factors that are dynamic factors, not static, and that's how Mr. Doe ended up as level 1. So I'm not sure I understand your argument that he was classified solely based on the characteristics of his offense, which are immutable.
Well, that is true. The hearing examiner did give consideration, mitigating consideration to those factors that would be static. But she based her decision that he was required to register entirely on characteristics of the sex offenses that took place long ago. And those things are static. And there was no explanation in her decision, no reasoned analysis as the cases require as to the predictive value of those kind of characteristics or whatever, which is, falls short of what, as I say, the cases require. I will note that I was just looking at the Superior Court decision, and the Superior Court decision, in the decision, the judge relies on an unpublished decision saying that the factors were given deliberate concerns to a predictive value or whatever. And they cite to Doe I have like little stickers all over here so that I can remember the names. I do very well in criminal cases with remembering the names, but with the numbers, I have to have little cheat sheets all around. But the hearing, the Superior Court judge cited to Doe 24-341, which my brief relies on quite greatly. And in fact, if you go to that decision for the proposition that that the judge cites it for, it doesn't say that. It doesn't say that. And so, yes, it is true, to get back to your question, that there were, that there was weight given to the, mitigating factors, the fact that he was in the community for all that long, that he was offense-free. But there's no explanation as to why he's required to register after.
It seemed to me that a key sentence in the hearing examiner's decision was in the discussion of, I believe it's factor 31, physical condition, where the examiner gives mitigating weight to the fact of his physical condition, but says it's not dispositive because there's no evidence he is so impaired that he couldn't commit an indecent assault and battery on a child if so inclined.
Well, that sort of starts to segue to the second issue as to the denial of the expert funds. And the hearing examiner faults the petitioner for not providing the very evidence that he sought funds for in order to show that relationship between his documented physical ailments, physical conditions, and the relationship with the risk to recidivate.
Were you looking for an expert to address whether he was so physically impaired that he couldn't commit an indecent assault and battery on a child, or whether he was inclined to commit an indecent assault and battery on a child, which goes to his reduced or absent libido and sexual dysfunction?
Well, I think it was both. I just want to sort of step back a minute. I will get to your question in a minute, but I did file a 16L letter citing to Doe 58574, which I think is that this exact situation. It's precisely this situation.
Well, that in that case, the Doe in that case came forward with information that showed that interferon that he was taking for his hepatitis would have an effect on libido. Now here we have in the record that he was on some heart medications. Do we have any information about what effect those heart medications may have on libido?
Well, yes, I believe at the hearing, as part of the hearing record, there was citation and I think provision of, but I know there was citation to, a website from the Cleveland Clinic showing that those particular medications could have an effect on that. But, again, in order to provide that kind of information, that was what he needed an expert for. Sort of getting back to your question, Judge Sachs, as to what kind of an expert that he would want. I think that was what you were asking.
Well, it was really whether he wanted an expert to address his physical ability to commit an indecent assault and battery or his inclination to commit an indecent assault and battery.
Well, I think that they are sort of somewhat tied together. I mean, he has a number of he had a number of significant physical ailments that would have an effect on his ability to physically, molest a child or whatever, but also the effects of medication that he was taking would have affected that as well. So I think it's probably sort of both is what he was looking for. And I think an expert who would have been, perhaps a cardiologist or maybe even, a general practitioner would be able to have provided that kind of information as to both of those subjects. So, I mean, I think that it's probably both, not to thread the needle too finely or whatever, but I should say, I think it was both sort of issues. I mean, of course, the issue is to someone as to whether they were able to sexually reoffend. And so that would be, very, very significant as well. But again, as I say, he was denied funds to provide the very information that the hearing examiner faulted him for not providing.
So what kind of a doctor would that be?
Well, I think it would be, it would be someone with the same qualifications as his Veterans Administrative doctor, who I think was, was a cardiologist. So as I say, it would be a cardiologist or, as I say, an internist, I guess, internal medicine type of person would be able to. So, I think that's what he was seeking. I know that the board faults him for not providing, not establishing, specifically enough as to what expert he needed. But I think when you combine his original motion for funds and then his renewed motion for funds, it's sufficient to show what kind of a physician he was looking for.
Well, ultimately, the board seems to, or the hearing examiner seems to say the request for funds on factor 31 is moot because I'm giving factor 31 mitigating weight.
Well,
how do you address that?
That's exactly the situation that happened in Doe 58-574. In that case, the hearing examiner gave the individual some mitigating weight and then also supplied their own expertise, which the court said was impermissible. And that's more or less exactly what happened here. The board says, well, they didn't need an expert because the hearing examiner could look at the medical evidence that was there and make a conclusion. Well, that's exactly what you need an expert for. And that's exactly what was denied and was in, as I say, that it's really this new case that came out is very much parallel to this situation. But, I would also, I also argue sort of getting back to the evidence of this. In the decision that the hearing examiner has, there's just really no, as I say, none of the reasoned analysis that we kind of have. She cites, the number of the factors, and they are admittedly high risk factors or statutory high risk factors, but there's no evidence as to the predictive value of these factors, especially after more than 20 years. And as it said in the brief, and the board actually argued that we were looking to invalidate factor 2029, but in fact we weren't looking to do that. We're looking to say that, look, this not continuing to give this weight to these high-risk factors after this passage of time flies in the face of the evidence that supports factor 29.
Is the board required to have a time factor ingredient in each of its other factors? Or isn't it permissible for the board to say, we're going to approach the passage of time offense-free in the community as a factor in and of itself, and not apply the passage of time to see how it bears on the predictive effect of multiple victims or repetitive compulsive conduct, all the other high-risk factors?
Well, in this case, admittedly, the hearing examiner gave mitigating weight to the time in the community, but it wasn't enough to overcome the fact that, she said, look, there are these characteristics of the offenses after this long period of time, and it's just not enough to not require him. And not to sort of be flip about this, I had this in the brief, but if these factors continue on unabated or unreduced ad infinitum, on indefinitely, you're going to have situations where you have a sex offender who's 101, bedridden, and they're still required to register. just that these factors just continue on, especially in the face of all of the scientific and statistical studies that I cited to in the brief and the reply brief from authorities that are SORB authorities, where they say that after 20 years, an individual who's been offense-free in the community, they're just like, sort of anyone else. They don't exhibit the same kind of risk.
I have a question about factor 2, the repetitive and compulsive conduct. I understand that the focus has mostly been on these 2 convictions for conduct against the 2 sisters with the initials J and K. But I saw that in the III, there's a reference to a plea to a misdemeanor about a month before those adjudications. And there's also something referred to as count 18 in the probation documents from Oregon. And it says that this is a different victim. So I understand that the hearing examiner and the judge both referred to 2 victims. Is that evidence in the record that there may have been 3 or even possibly 4 victims?
I think there's some evidence. I don't know about 4. I think there's some evidence that there may have been a third victim. I mean, there's very little documentation of that, and that's again that it's sort of thematically through this case. There's, the board and the hearing examiner sort of fault the plaintiff or, the petitioner for not providing this evidence. It was the board's, obligation to do that. I will say that with respect to factor 2, repetitive, it was applied in a limited manner because there was no evidence that this behavior continued on after detection or confrontation. So. I see that my time is expired. If anyone else would like to ask any questions?
Seeing none. Thank you. Thank you very much. We'll hear from Attorney Shanai, but stay with us. Thank you. In the courtroom there.
Good morning, Your Honors. David Shanai for the board. As for the issue on the expert witness fees, this case is substantially different than Doe 58574. Which was a case that I argued. The real distinction here is what the court was upset about was not that the hearing examiner denied the motion, because I made the counter argument that the individual didn't show the nexus between the actual need for an expert and the condition which he had, which would cause him to have a reduced sexual risk of reoffense. The court was upset about the fact that the hearing examiner said, we're going to deny the motion because factor, I think it was 31 they were using, factor 31 makes me the expert on this. And that's what the court was upset about. And that's why they basically sent the case back, because the hearing examiner not only claimed that factor made him an expert, so you don't need an expert, but then later said in the decision that he couldn't really make an assessment as to whether or not the interferon affected him because there was insubstantial records on that point. That was really the impetus behind Doe 58574's reversal. This case is different because, one, the individual did not tell us what kind of expert he needed. In fact, the hearing examiner spends time trying to figure out, well, what kind of expert would you have in this situation? And it's really incumbent on that individual to give us what type of expert he was requiring, because otherwise there's a good chance he'd go out and just get a psychiatrist or a psychologist who has expertise in sexual recidivism, as opposed to a medical doctor who actually has expertise in whether or not this individual's physical condition would in fact impair his ability to sexually reoffend.
Wasn't it at a minimum implicit in his renewed motion for an expert where he said, I went to my doctor at the VA, he was uncomfortable, he wouldn't give me anything more than a basic letter that listed the diagnoses. Isn't it implicit in that he wants someone who can provide the same kind of information that his own physician would have provided if cooperative. In other words, his physical condition and his inclination, if any, to engage in further sex offenses based on his medication and physical condition.
Correct. But what I'm saying is that he should at least give us an indication of whom he's going to hire so that we know that he has an expert lined up.
Does he have to give you a name?
Well, I think that would behoove him to at least give us an indication that he has an expert lined up and he needs the money for the expert.
But that wasn't ultimately the basis on which the board denied or the hearing examiner denied the motion for funds. Ultimately, it was essentially a decision that the request for funds was moot because the hearing examiner was going to give the factor 31 mitigating weight anyway. And what I hear your sister saying is, yes, but the expert could have helped the hearing examiner on how much mitigating weight to give factor 31. It's not an on or off switch, either mitigating weight or none. It's a question of degree. Why couldn't the expert have been helpful on that?
Well, because under these circumstances, the hearing examiner made the right decision by saying, we're going to give credit for factor 31, but still the evidence doesn't show that he is in a situation where he cannot at least minimally physically touch a child indecently.
If so inclined. Right.
But more importantly,
where the expert wanted the expert to give some evidence on whether he was so inclined. And the hearing examiner says, well, if he was so inclined, he could. So therefore, I'm going to find at least a low level of risk. Why couldn't the expert have contributed relevant evidence on that issue?
Because if we're going for the so inclined, I don't think the motions themselves were explicit in explaining that his condition gave him a nexus that showed he had a lowered risk of reoffense, and therefore an expert was required. And I think the hearing examiner, if you look at what's interesting about this case, if you look at what his sister says, if you read the case initially and you read the affidavit for the motion, you would think this individual was barely able to move. But the sister says that he helps maintain the home. He does house projects. He maintains his own car. He fixes things around the house. He goes for walks with his dog, although short walks. He keeps his basement clean. He goes grocery shopping.
So he might have the physical ability. He can move his hands. He can commit an indecent assault and battery in theory.
Correct.
But the question is, and the hearing examiner said, if so inclined. And that's where I'm having a problem, because it seems to me that if so inclined is speculation, and Mr. Doe wanted an expert, if only an internal medicine person or a cardiologist, to testify that he doesn't have any such inclination.
I guess the question becomes, how does a cardiologist say that? I mean, he's not a
based on the
psychiatrist.
medications he's got and based on the cardiologist's exam of Mr. Doe.
Right, but the document he provided with the court didn't say that all individuals on this medication suffer sexual dysfunction, nor does sexual dysfunction necessarily mean that he still doesn't have a deviancy where he may touch a child.
Let's distinguish between sexual dysfunction in the physical sense and loss of libido.
Well, again, loss of libido, I think you would need a psychiatrist, not a medical doctor, because a psychiatrist would talk about how loss of libido can correlate to an individual who has a reduced sex drive and their risk of reoffense issues. I don't think a cardiologist can say, because he has a lowered libido, without even considering whether or not he has a deviancy as established by his sexual offending behaviors, just because he has reduced libido doesn't mean that he is not capable of committing a sex offense against a child if he's so inclined. And I think that's the distinction there. So that's why it's important that the type of expert that's required be at least enunciated to the hearing examiner so they can figure out whether or not that it's a legitimate situation. Again, all they said was we need basically a licensed independent person to do an evaluation.
Well, I'm looking at his motion for funds at pages, I think it's 259 to 60 of the record appendix. I'm not sure I'm using the right page numbers, but He's prescribed medications for his heart and related ailments. There's evidence that side effects from these medications have negatively impacted his sexual functioning. A probation document indicates that his treatment provider says he tends to suffer from depression, becoming sexually dysfunctional, primarily due to heart medication. Heart and vascular disease, along with depression, are recognized as causes of sexual dysfunction. Petitioner reports he last had sexual relations in 2009, no longer able to obtain an erection, lacks any sexual drive. Doesn't that make out a prima facie case for getting an expert to testify how his medical condition and the medications he's taking affect his inclination to engage in the indecent assault and battery that the hearing examiner pinned her decision on?
Well, I think what the hearing examiner, again, keeping in mind, the hearing examiner at the classification decision-making process was still considering whether an expert was required. Because if you read, it was held without prejudice and then reconsidered at the
Right.
classification
but I'm saying,
analysis.
reading that for the purpose of making clear why he wanted an expert.
Correct.
It
And what
seems
the
to me
hearing
he
examiner
did draw
says,
an
looking at all the evidence and that motion and the renewed motion, after looking at all the evidence, the hearing examiner said, I'm giving full credit for it. I'm giving him full credit for his physical condition.
Well, what does
All
full credit mean?
means that he gets full mitigating weight
So
for that factor.
But couldn't factor 31 in some cases lead to a decision that the petitioner presents no risk?
I think that it could in certain circumstances. Again,
All right. So that would be full weight.
right now.
He didn't get full weight here. He
Right.
got weight.
He got weight.
But an expert could
again,
have shed some light on how much maybe more weight he should have gotten.
possibly, but then again, you're assuming an expert was going to say, and I don't think an expert would say that this individual was at no risk to reoffend because of his physical condition. I mean, we don't know the answer to that, but
Right. It doesn't have to be no risk. The courts have made clear. It has to be some cognizable, non-hypothetical risk.
right, which we have here with his prior behaviors. There is a cognizable risk, and that's what the hearing examiner was trying to put together, was the fact that this isn't an individual who went out and raped a woman or sexually offended against a stranger. This is an individual who, for 4 years, sexually abused 2 children. That shows a deviancy under factors 2 and especially factor 3. There's a deviance there with prepubescent children. That's the cognizable risk that the hearing examiner could not get past. When you go to her analysis of the evidence, she said all of these positive factors reduce him tremendously, but she could not get past the fact that he committed 4 years of deviant sexual behavior against 2 children. And I think she was very clear in that. And again, it was the deviancy that caused her not to give the full mitigating risk. And I'm not sure an expert was going to change that, because again, it's that deviancy that changes the whole analysis, so to speak, as to his ability or desire. It's not so much whether he has a desire right now to sexually offend. He has at least a history of a deviancy that made the hearing examiner believe that it could occur under the right circumstances, and that this individual physically could still do that based on not only the lack of records showing that he was completely disabled, but if you look at the sister's letter, he's very physically active for someone with his conditions. So it's not like it's out of the realm of possibility that there could be a moment where this individual could touch a child indecently if given the opportunity and the inclination. Now, again, this court might not agree with the hearing examiner's decision. I have to say, we have a lot of these level 1s coming up that are especially on the reclassifications where we reduced them to 3s down to 1s. And you're going to see a lot of these cases where it's a close call, and the hearing examiner will explain why they decide to stay with a 1 and not relieve somebody. But unless you find that conclusion is such that you would make a necessarily different one, unless you find there's some substantial basis for that conclusion, it's up to this court to accept the hearing examiner's decision on that matter.
I suppose we'd never see a 0 because there wouldn't be an appeal in that situation. But are the boards is the board ever relieving anybody?
Actually, since we've started the process of reclassifying every 3 years with the burden on the board by clear and convincing evidence, we've been relieving a number of people, especially at the recommendation stage where we write them a letter saying that we have agreed to terminate your registration requirements. That is increasing. And the reason why you never see a zero is because they then are off of our rolls and they're off of our list. But that is increasing, and I'm seeing a lot more reductions from 3s to 1s, 2 to 1s, because now that we're doing it every 3 years, we're keeping on track of what people are doing. And now that the burden is on us every 3 years to prove by clear and convincing evidence the current risk and danger, we're finding with the recent studies and the new regulations that offense-free time does matter. That,
But even to be a 1, there
aging
has
does
to be
matter.
clear and convincing evidence, right?
Correct. On a
The board has to
reclassification,
prove.
we have to prove clear and convincing evidence. So things like time, offense-free time, age, those are becoming big factors in these reclassification cases. And it was a big factor in this case. This individual, the hearing examiner reduced them down to 1 because of all the positive things that have occurred in this individual's life in the last 24 years. She just wasn't ready at this point because of the deviant type of sexual behavior to actually relieve him. Now, keep in mind, even though we have the issue about lifetime registration, the Supreme Court has already said that that does not work if an individual can show, if you can't show that he still poses some cognizable risk or danger, even if he has a lifetime registration, we have to relieve him. So that's where we are in the process. And again, this individual, the board wanted a 2 in this matter. And I can guarantee you, when I started doing this 10 years ago, under the old preponderance of the standard, he would have been a 2 and maybe a 3. But under the new standards that we have between the new burden of proof, the new regulations, this individual was dropped down to a 1. And I think that just shows that the system is working. We're getting to try to find the fairest end result for these cases. And again, what's interesting about this case, I believe in December of 2020, sometime this month, he's eligible for reclassification again. So, you know, and that's one of the things I'm finding is that I start these cases, by the time I get done with the appeal from the very hearing all the way to the appeal, it's time to start the reclassification again. It's kind of gotten to be a treadmill, and I'm starting to get to know these cases pretty closely, but you know, that's the nature of the business. I see I'm running out of time, so if there's no other questions, I'm willing to rest on my
I have a
brief.
quick question. I just was wondering if you could shed any light on the question I asked your sister as to where in the record, if anywhere, is there evidence of a showing that Doe made as to the specific side effects of the medications he was taking? I understand the medications are in the record. Is there a page from the PDR or anything like that that would show these medications cause decreased libido or erectile dysfunction?
No, the only thing he did is he cited a study that was on the computer, and what that study said was 31% of all men suffer from some type of sexual dysfunction, and that heart medication or heart disease, it can be a contributing factor to that condition. It doesn't specifically say 90% of people who have heart conditions have sexual dysfunction. The only real evidence of sexual dysfunction was his own self-reporting on that issue. And again,
that's the Cleveland Clinic website?
Yes.
So there's nothing that says someone who takes diloxin or whatever it's called may have this side effect?
To my knowledge, no evidence of that was presented to the hearing examiner either for the motion or at the hearing.
Thank you.
Thank you.
Thank you both. We'll take it under advisement. And,
Thank you. Have a nice day.
Case is now being recorded.
Thank you. Good afternoon and welcome to the Appeals Court Oral Argument Session for December 1, 2020. There's only one party arguing this case, so you'll have 15 minutes. This is an impounded case, so don't name names. Speak to your client and the complainer, the whatever, but just don't, or you can call her TW. You have so calling the case. It's 19P 1793 TW versus RH, and Attorney DeCrescentis representing RH.
Yes. Thank you. Distinguished members of the panel, thank you for the opportunity to speak today. Again, Attorney DeCrescentis, for the record, representing RH, the appellant in this matter. Your Honors, the issue is that this order was issued out of the Rentham District Court back on September 9th of 2019. That was before the Honorable Stephen Thomas. At that time, after hearing, Judge Thomas did find 3 or more acts sufficient under Chapter 258E, Section 1, and did issue that order for 1 year. On September 9th of 2020, this matter went back before the Rentham District Court on the 1-year extension date. At that time, the Honorable Stephen Thomas again presided. Sua sponte, he did recuse himself as a result of the pending appeal, which is currently before the panel. The matter was...
Don't give us the, I don't think we should hear what the result of that hearing was, because we want to determine this on the evidence that's before us. Unless my panel members want to hear. I think no, okay.
Well, are you suggesting that, are you going to tell us that the case is moot somehow?
Well, no, so I don't think it would be moot. Basically, if the order was not further extended at that further date in front of another judge, it would still not be moot. Under the case law, there are multiple appeals panels that have heard this issue. Gassman v. Reason is probably the one that pops into my head.
There's still the record.
Correct.
Okay.
There's the record to be fixed, as well as any collateral consequences that come therefrom, as well as any.
Yeah. If it had been vacated as improperly entering in the first place, then you'd be telling us it's moot. But it's evidently that didn't happen, and perhaps we don't need to know anymore.
Again, the issue being whether or not there were 3 or more acts committed by RH against TW directed at her with the intent to cause fear, intimidation, or abuse, and that did in fact do so. Again, in looking at the allegations that were given at the time of the hearing, there were 4 main incidents that were brought up. One being that on August 5th of 2019, she became aware that he apparently had taken employment in the area of her secondary workplace. That was not established in the record that in fact he did obtain employment in that area. In fact, she had received that information, it would appear, from a third party, but that in fact was not true. Nonetheless, she was not apparently aware of his presence there until the following day. She was told that that he was indeed present there. There was nothing to suggest that either she was present there, that he knew that she was employed in that area, that he had reason to believe that she would be present, nor that he did any overt act to either get her attention or to intimidate her in any way. If anything, the record seems to suggest that indeed what had occurred, if anything, would have been incidental contact, or the fact that he would have been present in an area which she could or recently would have had access to. As a result, I would suggest that there was insufficient evidence for that to be an act under 258E Section 1, and that it should not be considered as such. There was another allegation that was indicated on August 4th of 2019. There was information received by her that an email was sent by RH to the board where he was previously employed and where she was working as an independent contractor. That email was sent originally to RH by a young performer's father. It was about compensation, monetary compensation that young performer had not received that she was apparently supposed to. He had forwarded.
I'm sorry, is the email in the record?
It is not. So the email was never presented, nor it still has not been presented. So it was not on the record. The testimony, however, about the content of the messages essentially was that It was about this young performer, and it was about monetary compensation. There was nothing presented in the record, nor do I have any reason to believe there was any threat of physical harm or anything of that nature. It was simply that RH had forwarded that email along with basically to the board in order to address the concerns. This is similar to other cases that have held, like Cindy v. Morhe, a 2014 Supreme Judicial Court case, which does state that any concern about professional reputation or fear of economic loss, unfavorable publicity, or loss of the ballot box would be insufficient. There was nothing, again, presented in the record, nor was there in the email, that would be a threat of physical harm. And in fact, TW did concede as much during the hearing. In the transcript, it does indicate that she said that her concern at the time was damage to her professional reputation. So again, it was not sent directly to her, it was sent to the board. She became aware of it later, so it was not even directed at her. So again, an insufficient act under 258E. There was also another allegation that in the center of town, there's a roadway that goes around the center of town. RH was present at the corner of that intersection and was looking in the direction of the Common or somewhere around that area. She states that she had driven around the Common, essentially towards him, and then had driven past him. At that point, she asserts that he had stared at her and had walked towards her as she was stopped at a subsequent intersection. So the accusation being that he would have walked essentially behind her, seemingly making eye contact with her through the rearview mirror, and that she was placed in fear at that time. Again, very similar to the August 5th incident, I would suggest this is incidental contact. This is a common roadway. He's walking on a sidewalk. I would suggest that the evidence as presented in the record is insufficient to suggest that it was done with any intent to place her in fear. And I would suggest, based upon the lack of willful, malicious, or intentional behavior, that also should not be considered an act. Finally, there was one allegation on May 28th of 2019, that being an assault and battery allegation. The incident being that when he was still employed by the board, he was in charge of changing over the set from her initial performance or practice session for another group that was going to have the slot after them. There was a rush in doing so. He was attempting to clear that set. She states that as she was standing on the stairway in what was described as her to be kind of a chaotic and busy place. She had 30 some odd students, I believe she said, were there. Parents of those young children were there, and also the performers for each set block. She states that during this rush that he walked down the staircase, making contact with her, she asserted that it was intentional conduct when pressed by counsel because of the fact that there were multiple ways to get off of the stage. I would suggest that based upon all the evidence presented in the affidavit, as well as at the hearing, I would suggest this was equally consistent with some sort of incidental or accidental contact, that it was not intended to place her in fear.
Didn't she say that she was standing there and he wanted to get by, and she said something like, "What, are you want me to jump off?" And then he pushes past her. It seems like it's fairly intentional.
I believe that was the accusation, Judge, in the way that she had relayed it. I would suggest, however, based upon the evidence that was presented, that it's equally consistent with an accident. She had stated that she was blocked in, I believe, by other individuals below her. It was a busy area. She did indicate that she did not ask him or tell him anything about the incident, ask for an apology or explain that she was disturbed by this conduct, and also she didn't.
Assault and battery charges grew out of?
Yes, there is an accusation of an assault and battery charge out of that incident. Yes. Again, I would just suggest that based upon the record as it was presented, that it's equally consistent with an accident.
What about her testimony that after the incident on the stage, he in the lobby accused her of making all the children cry. Could those be considered to be two separate incidents of harassment?
No, I would say it's not. First of all, temporally, I don't think they're separated enough. I think that the case law would
So if he
suggest.
hit her once on the stage and once in the lobby, those would be the same incident because they're temporally close?
Well, I do think it's also different, Your Honor, in the sense that the verbal communication between him, so that any statements that he may have made in the lobby, again, I don't think would be sufficient for an act because it's not a true threat. It's not fighting words. It may provide context, I suppose, for any fear that she may have, but I still think definitionally it would not qualify as an act.
But he's threatening to cancel the show in front of the children who started to squeal and wail and cry. And he accused her of making the children cry. And so that's not a threat. It's not
No.
harassment.
No, I don't think it can be, Judge. Under 258 Section 1, it would have to be a threat of physical harm or a threat to personal property. Again, this is more similar to, again, unfavorable publicity, fear of economic loss. I would just suggest that it cannot be. Under the First Amendment, again, it had to be true threats or fighting words, and it certainly does not qualify, in my opinion, to be either of those.
What about her testimony as far as property? What about her testimony that between the end of May and early August, she referred to it as he was harassing her by, on 3 occasions, canceling when she had arranged to retrieve her property, her props,
Right.
from the theater?
Sure. So again, Judge, again, I think it's a difference between what would be known in the colloquial sense as harassment, right, and what would be harassment under the statute. Again, it would not qualify to be an act of harassment. Whether or not there's a strained business relationship, which I frankly think is quite clear from the record. Again, the fact that there may have been some sort of an inconvenience caused, or maybe not the best personal relationship between these two parties does not make it in and of itself certainly an allegation of an act that could qualify under 258 Section 1. I think if there were no further questions at this time, I could rely on my brief.
Seeing none, thank you. We will, of course, take the case under